Good day, Crime Talk aficionados. It's Saturday, so what does that mean? It's our weekly recap of the top stories of the week, and it's been a busy week. So if you missed something, watch the recap here today. Have a wonderful day, and we'll see you next time on Crime Talk. First on the docket, a tale of two ways of handling matters in the Vallow Daybell matter. Okay, now I have stated that I don't particularly like Mark Means' style of lawyering. It's kind of that civil litigator kind of stuff, which just really bugs me because it's always trying to pay this gotcha and hold you in contempt and, blah, blah, blah. It's just what gives lawyers a bad name. Okay. Mr. Pryor, who represents Chad Daybell, I think he's been around, done criminal defense. He gets it. There are certain hills that you're willing to go die on, and there's others that just aren't worth a fight. So let's take a quick example. Now, the prosecutor in the Lori Vallow Chad Daybell matters are supposed to turn over discovery. And Mark Means made a request for discovery to be turned over. And basically, the state hasn't complied with that yet. Now, I wouldn't put this little caveat in there is, I wonder if Mr. Means recalls that the proceedings were stayed while his client is off being restored into competency. So I'm not even sure that the district attorney didn't comply because, frankly, they're not even at first advisement yet for the case really to be started. But in typical Mark Means fashion, he said he wants a motion to compel. He basically says the discovery should have been turned over, and the prosecutors are just evil, bad people. He wants a hearing immediately. He provides notice of reservations of rights regarding this matter, including but not limited to requests for dismissal, Brady motion violations, and sanctions. Well, first of all, there's not going to be a dismissal, okay? A Brady violation is something when you withhold exculpatory information. Not going to happen. Sanctions? Really? I think the judge will admonish Mr. Means and say, your case is stayed. Why are you going forward in this? And then ultimately he asks that the court impose cost, fees, and other appropriate sanctions against the prosecutors. Not going to happen. Then we have an example of Mr. Pryor. He has to file basically motions to dismiss if there are imperfections with the indictment within 14 days of the last court hearing. Well, all the discovery hasn't been turned over yet. So what does Mr. Pryor do? Instead of asking for sanctions and motions to compel, he says, Judge, can I get an extension because the discovery hasn't been turned over yet? I've communicated with the district attorney, and we should have it here shortly. That's our request. Which is the more professional way of handling things? This way, okay? This way is the way you handle these things. I understand this is the biggest case Mark Means has ever had. It's his first real criminal case. But scorched earth is not a way to go in and try to prevail for your case. You lose credibility when all you do is cry wolf, that everything is a constitutional violation and everything requires dismissal. Shows a lack of experience and professionalism. We'll see. Now, the other thing that's interesting in the Lori Vallow matter is that the court had sealed a hearing that took place back in July 27th of 2020. Well, the court allowed that hearing to be unsealed. Why, you may ask? For review by the special prosecutor appointed in these cases. Now, I went back and looked to see what took place on the 27th, and it was something that was done in chambers, so it was sealed. We don't know exactly what was said, but apparently somebody at the district attorney's office thinks that there's something in there worth reviewing or having a copy of. Some people commented yesterday that there was nothing about Lori Vallow and Chad Daybell. Hey, you just have to wait a day or so, and then something always comes up. And thank goodness for Mark Means. I should send him a mug simply for the fact that he provides such good content. Next on the docket, the news media, as well as Crime Talk, believes that the Chaffee County District Court judge in the Barry Morphew matter got it wrong when he refused to grant release of the affidavit for the arrest warrant. Several news organizations have asked the Chaffee County District Court judge to reconsider his June 4th order sealing the 130-page arrest warrant for Barry Morphew. Now, the judge did note in his order that he said it is the lengthiest and most detailed affidavit for an arrest warrant that he has seen in his nearly 30 years of experience with criminal cases. The judge, Patrick Murphy, closed the record until at least September. He wrote that releasing the affidavit prior to an investigation conducted by Barry Morphew's defense attorneys could hamper their ability to effectively prepare a case. The judge also raised concerns in his order about the potential for harassment of the Morphew's two daughters and the affidavit's length, writing that redaction would be a time-consuming process and one the court cannot meaningfully complete without the input and involvement of both parties. But the news media argues that the affidavit's length and details contained in the document are not legitimate grounds to deny the public's presumptive right to inspect the affidavit. And we here at Crime Talk agree. So the Colorado Rules of Criminal Procedure have recently been changed to address this issue. Specifically, it's Rule 55.1. It actually went into effect on May 10th of this year, and it imposes a heightened burden on any party seeking to overcome the public's strong presumptive right to access to court records. Even if the affidavit contains extremely sensitive personal or private information unrelated to the prosecution's need for the arrest warrant, Rule 55.1 provides that such information may be redacted, but only upon a judicial finding that its disclosure would countervail some specified substantial interest. And attorneys for the news media argue that Barry Morphew's own investigation is not a substantial interest, according to the attorney's arguments, because criminal defendants are not required to produce any evidence from an investigation at trial. Their goal is to show that the prosecution's investigation was inadequate. Additionally, the party who is asking this court to deny the public is presumptive right to access court records. The defendant, in this case, Barry Morphew, should bear the burden of showing that the public disclosure of each page, each paragraph, each sentence, each word in the affidavit poses a substantial and real threat to his ability to prepare and present his defense. The attorneys for the press argue none of this has been done. I totally agree. The burden is on the defense to say why it should be done. And guess what? That's going to be time-consuming and expensive. And the court to simply say it's going to be too much work is not a rational basis to deny the release for the affidavit. There's nothing in the rule that simply says something's going to be time-consuming or burdensome, somehow suspends or the rule should be disregarded by the court simply because they don't have the time to do it. What is also interesting in this particular case is that the prosecutor is not objecting to the affidavit being released, which is always somewhat interesting because oftentimes it's the prosecutor that doesn't want the information released. Here, it's the defense. I cannot recall a single time that an affidavit has not been released to the public immediately here in the state of Colorado. Even with this new rule, I think the court, with all due respect, got it wrong in this particular case. And if the court denies the press's motion to have the affidavit released, hopefully it will be taken up on a writ directly to the Colorado Supreme Court, and this issue can be resolved. The public has a right to public information when it can be reasonably made available. And in this particular case, the defense hasn't shown any evidence that it's going to prejudice them in any way. I think the court should reconsider. But I can tell you this, most courts don't like to admit that they got it wrong, and they're going to stand by their decision. We'll see if the judge has the courage to maybe change his mind. All right, let's take a quick recess before we continue with the docket. Please go to CrimeTalkSearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to CrimeTalkSearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to CrimeTalkSearch.com, sign up today. You'll be happy you did. Let's meet the woman who's developed, in her own words, a close and intimate relationship with Chris Watts. Her name is Krista Raquello. Now, she spoke on camera for a series that's coming out called Cellmate Secrets, in which not only we find out more about the pair's relationships, but also looks at Chris Watts' life in jail. Now, the 42-year-old clinical psychologist, Krista Raquello, admitted to developing a close and intimate relationship with Chris Watts and his cellmate, Dylan Talman, after sending Chris Watts fan letters in prison. Krista is now actually engaged to the cellmate, Dylan, and talks about her fascination with Chris Watts' case, saying she found it very odd the way the case was handled. Usually these cases drag on for years, but he pled guilty, and she says, well, the case was never investigated, et cetera, et cetera. Now, Ms. Raquello is a former psychologist that has worked in prisons, and apparently she has a fascination with high-profile cases and people that have been accused of committing multiple murders. Her mother apparently was a big fan of Charles Manson, and if you look at the photos of Charles Manson and the photo of her father, they look very similar to Charles Manson. She used to go see her father in prison, so she's got some connection to prison. This is going to be an interesting little story because I just don't understand it. Chris Watts killed his wife, Shanann, who was 15 weeks pregnant, their two daughters, Bella, 4, and Celeste, 3. Now, past performance is indicative of future results. I've never understood it, and I've seen it time and time again, where women somehow think they're going to change somebody or become a fixer for a project, which is a good way to describe it. I've said this before. Oftentimes women look at men hoping to change them, and men look at women hoping that they'll never change. Usually not very compatible when it comes to that. I don't get it why the women always want to date the bad boy. How about you go date the nice guy, the responsible guy? I don't understand it when the responsible nice guys can't get a date, but the bad boy with no job, a parole officer, multiple kids with children by multiple women, always seem to have a plethora of women throwing themselves at the guy's feet. I just don't get it. I'll never understand it. Ladies and gentlemen, go date the nice, responsible guy. We'll see if Miss Raquello's engagement works out with Dylan. Maybe Chris Watts could be the best man. Next on the docket, some news came out regarding the Murdaugh case in South Carolina. As most people know, if they've been following this program, we've been following this. Maggie and Paul Murdaugh were found dead on the grounds of their 1,700-acre South Carolina property. No suspects as of this time, but the police are trying to figure out why Maggie Murdaugh's phone was found on a rural road off the grounds of the property. Apparently, a relative was able to ping the location of Maggie's phone a day after the mother and son were found dead, and it tracked it to the location, which was outside the property. Doesn't make a whole lot of sense. The police have recovered that phone, obviously something of evidentiary value. Hopefully, there will be some DNA on that phone, which will give some indication as to who may be responsible for both of these individuals' death. It did rain that night, so it'll be questionable if any DNA will be able to be recovered and tested. All right, not to say I called it, but I called it. I said last week at our live show, I thought the appropriate sentence was going to be 20 to 25 years. The Judge Peter Cahill, gave Derek Chauvin a sentence of 22.5 years, 22 and a half years. The court found that there were aggravating factors which warranted a sentence greater than the 12-year sentence, 12 and a half year sentence that he probably would have guidelined out for. And the reason the judge gave that sentence is because of those aggravating factors of, one, that he abused his authority as a police officer, and second, the way that he treated George Floyd with cruelty. He received 199 days of pre-sentence confinement credit. We won't go into all of that, but if you want to watch the entire sentencing along with my analysis based upon the 15-minute break that the court took before he imposed the sentence and announced the sentence, I encourage you to do that. We can put a link up for that as well. Have a wonderful day. We'll see you next time on Crime Talk.